Today I'm talking about intellectual property and licensing. Let's see. I've been doing web development of various sorts since about 1995, maybe 94. Been in IT since 93 or 4. I started learning HTML in 1995. Since 2006, I've mostly been doing Ruby and Rails. So I'll make it for the Ruby meetup, which meets next Monday, or this coming Monday. We're actually having lightning talks, so if you've got a topic that you can spend 5 minutes, we'll probably let you do 10 if you wanted, really. I would say it only has to be tech adjacent. It doesn't even have to be Ruby adjacent. Sign up on Meetup and come on out. Let's see. So I also ran the St. Louis Linux user groups for many years. I think the first version of this talk I gave was at that group. So I learned a lot about GNU Linux, and because GNU Linux is free software, open source, I got interested in this whole topic and wanted to learn, like, what is the difference between copyright and trademark? Like, how's that all work? So well, I'll be trying to convey a lot of that to you. My Twitter handle is over there in the lower left. It might be pretty dim for those in the back. CraigBuchek. And if you want to follow along now or later with the slides, CraigBuchek.com/intellectual-property. And you can see my presenter notes if you hit P. And so some of the stuff I actually put in the presenter notes I won't talk about. It's just kind of extra information. But not everything's in the presenter notes either. All righty. All right, first of all, I'm not a lawyer. This is not legal advice. Standard disclaimer. If you need legal help, contact a lawyer. I've got a few places where I'll tell you specifically where it's probably a good idea to do that. All right, so the founding fathers actually spent quite a bit of time worrying about intellectual property. I'm not sure that the term had been coined yet, but so Thomas Jefferson in 1813 said, "He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at mine receives light without darkening me." So it's the idea of, if you've got a candle, you're lighting one candle from another, it doesn't extinguish your candle. That's kind of how knowledge works. These are the 3 primary types of intellectual property: copyright, trademark, patent. These are the ones we'll be talking about tonight mostly, especially copyright. Frequently you'll see this abbreviated as IP, which is very confusing. Internet protocol, your IP address, like that's a completely different IP. So context matters, right? Turns out there's a lot of other types of intellectual property. Some of these I just learned in the past week or so. Trade secret is basically, it's almost more contractual. Basically, it's the secret recipe for Budweiser beer or something. If you work for Anheuser-Busch, you had that trade secret and you disclose it to someone else, you'd be in big trouble. If you received that stolen information, you'd be in big trouble. Moral rights are sort of related to copyright. They're the rights of attribution or to be published anonymously or pseudonymous? All right, I give up. Under a pseudonym. And the right to the integrity of the work, although I'm not sure that we have those moral rights in the United States. I'll talk a little bit about integrity of the work a little bit later. Let's see, trade dress. It's sort of like the colors used on the Coca-Cola can or something like that. Geographical indication is something I kind of knew a little bit about. I hadn't thought of it as intellectual property. To call yourself champagne, you have to be a sparkling wine made in the Champagne region of France. That is a geographical indication. There's a lot of these things. I looked at the Wikipedia article on the list of them for Italy, and there were 222 of them. Another couple examples, Asiago cheese and cognac are some other ones of those. And they'll have some A lot of times they'll have the product description, and it'll have like letters like PDO or DOC or DO, depending on the country, and it's very complex. It is very complex, like all the different possibilities of each country, each language, a lot of things going on there. A certification mark. You might see Energy Star or UL listed. Those are, you can only use those if you meet those criteria that those companies have set. Good housekeeping mark actually is another one of those. This is another one new to me, indigenous intellectual property. So this is a kind of a newer concept actually. So some Native American tribes have requested that museums not actually cover anything about them, like so their songs, anything about their culture, and so some countries have started giving them certain rights to their cultural assets, I guess. Plant variety rights. So if you grow it's not a species, it's a subspecies, it's a cultivar of roses, you can give that a name, and you can make sure no one else uses that name or those genetics somehow. Don't know the full story on that one, but that's another type of intellectual property. A mask work, another one I learned, is for electronic circuit designs. So apparently doesn't quite fall under patent or copyright, so they gave them their own little thing. Database rights, I don't believe that we have them in the US, but Europe has that sort of a collection of data. I think there was a case in the US with the Yellow Pages. Someone copied all the numbers out of the Yellow Pages, and they're like, that's not copyrighted. Like, that's just information. And the right of publicity, which is, your name and your picture being used to advertise things. Like, they can't just go use your name in your picture. All right. So we call this intellectual property, but it's not quite like physical property. So physical property has a characteristic called rivalrous, which means that only one person can have it. But like Thomas Jefferson's analogy, if I have a copy of a program, it doesn't prevent you, if you get a copy, it doesn't take my copy away. And same with ideas, you can't. So we have these ways of dealing with them. They're not necessarily natural, whereas, only one person can own, that laptop because he's going to take it home with him, and I can't take it home with me because he took it home with him. Whereas, software and these more nebulous concepts don't have that. So sometimes we do it just by force of law. Sometimes there's some natural things, but mostly it's just, these are laws that we made up to help us deal with these things. So intellectual works are non-rivalrous, which means they can't be used up. And they don't affect the value of the original copy. One concept we'll talk about a little later that I need to talk about now to understand it is a work for hire. So if you work for a company and you're writing software, that's a work for hire. They own it, not you. And same with patents, actually. If you and sometimes this will be in your agreement, especially with patent, because patent's a little more fuzzy on who owns if it's a work for hire or not. Whereas copyright is a little more clear cut. If you're writing it for a company, it's theirs. So copyright and patent, actually pretty much any of your rights can be transferred for those two types of intellectual property to anyone else you want to. And in fact, they will, when you die, actually, they would be transferred to your heirs on those two particularly, if you still own them. All right, so we'll start out with copyright. It's the big one. So a copyright applies to most works in a fixed, tangible format. So it's authorized by the US Constitution. I'll get to that in a minute. And the majority of the talk was going to be on this and the licensing of copyrighted things. So this comes from Title 17 of the US Code. It's actually fairly readable. I have read quite a bit of it trying to understand, like, okay, let's go to the original sources, see what they say. And it's pretty readable, actually. Let's see. I'm going to gloss over part of this history. It's probably a bit more than we need to cover right now. Before the printing press, it wasn't necessary because it took so long to handwrite things that you didn't have that many copies to start with. Originally it was the publishers actually held the monopoly, not the author. Now it's the author since the Statute of Anne, 1710. It's owned by the author of the work, not the publishers. It is established in the U.S. Constitution, or at least referenced. And then the Copyright Act of 1790 is almost an exact copy of the Statute of Anne, which is kind of funny. Which, if you think about it, was it a copyright violation to do that? I don't know. Let's see. All right, so this is the Copyright Clause, or the Copyright and Patent Clause of the U.S. Constitution. It's one of the enumerated powers of Congress. It's Article 1, Section 8, Clause 8. Congress shall have power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. All right, so I got this list mostly from copyright.gov. They got a lot of brochures and frequently asked questions with answers. So you can copyright any literary work, a book, that's pretty much the original, musical works and lyrics, dramatic works, a play, but it's not the play as presented, it's the play as written. It has to be in tangible physical form. Pantomimes and choreographic works, I had to look up what a pantomime was. It's pretty much mime. It is pretty much, it's similar to choreography. You know, it's a pantomime is sort of a play with no words, I guess is a good way to put it. Pictorial, graphic, and sculptural works, motion pictures, other audiovisual works, sound recordings, and architectural works. One interesting thing that I note is that music has two different ways to copyright the same thing. So you've got the musical work and lyrics. So you write a tune, you write that tune down in musical notation, probably with words, some probably arrangement, that's copyrighted. And then you make a recording of that song, that's a separate copyright. So interesting that it has two different ways to copyright the same thing. So you buy an album, it's going to have two separate copyrights going on. So the publishing rights are usually, BMG Music Group or something like that. And the record is probably is copyrighted by EMI or whoever, or Sony, whoever the record publisher is. Although it could be owned by they could actually be owned both by the artists themselves. And if you do download the talk, there is a link to the original source of this from the copyright.gov. All right, things that are not copyrightable. Titles, names, short phrases, slogans, URLs can't be copyrighted, but they probably can be trademarked. We'll get to that. So if it's short and small, probably not copyrightable at all. Ideas, procedures, methods, processes, principles, and discoveries, things that can be patented, but they can't be copyrighted. Familiar symbols or designs, you can't copyright the copyright symbol or the happy face. Although actually there is a trademark on the happy face. That's a weird one, actually. Typefaces, fonts, and lettering. I'm not 100%. I think maybe you can get a design pattern on a font, because I know you have to license them, so I don't quite understand that one. Layouts, formats, designs, blank forms. I found this a little interesting because you would think that like a scorecard could maybe be copyrighted, but apparently not. Recipes cannot be copyrighted. I found that a little bit interesting because there is some creativity in there, and they're in a fixed form, and it seemed like it should be able to. Luckily, they're not, because that would pretty much ruin the whole sharing of recipes that we've had since probably before the printing press.
So I'm thinking KFC, the 11 secret or
That probably gets into trade secret.
Oh, yeah.
But to mention, jump in, ask questions anytime you want. This can be a conversation if you folks want it to be. Yeah, so you can't copyright the list of ingredients, but you can make it a trade secret, and someone would get in trouble for sharing it at that point.
You see it written down somewhere, not knowing that it's a trade secret.
So in some ways that's stolen property, and I think it'd be fall under the same issue as stolen property. Although it was stolen and left somewhere, it gets really gray right there, right? Talk to a lawyer. That's a place you should talk to a lawyer if you get in that situation. Yeah. All right. So what rights does the copyright give you? If you own a copyright, what does that mean? It means that you have the exclusive rights to do these things, that you can decide that nobody else gets to do these, or you can give that right away. You can authorize others to exercise these rights. So you can make copies of the work. It's the right to copy. That's exactly what it means. And in some ways, that's really the only important one, or at least it's the most important one, because most of the other ones imply there's some copying going on. So I don't know why we even bother with the others in some ways, because they can't be done without copying, except for one or two of them. Prepare derivative works. Okay, so let's say Chris wrote a piece of software, and I took that, I made it do something else. That's a derivative work. But to do that, I had to copy his parts, probably get rid of some, add some more. Work still has the copyright on the original. The combination, I probably own the copyright on my part. The combination is probably jointly held between the two of us. Let's see. All right, you have the right to distribute copies of the work to the public, or not actually distribute it if you want it to not be distributed. That's your prerogative. So you can either sell it, transfer ownership, you can lend it, lease it, rent it, however you want. So this one isn't quite a copy, but performing the work publicly. So if you write a play or a pantomime, you're the one that gets to decide who can put that on. Displaying the work publicly, if it's a statue, you can decide, someone can't just take your statue and put it wherever they want. That's a little weird one, because the individual copy, I guess someone can't copy it and put it on in their front lawn. So in some ways that requires a copy with the statue, because there is a distinction between the work and the physical embodiment of that work. So like if I give you a book, that doesn't mean you own the copyright to that book. That just means you own that particular copy. And you can mostly do anything you want with the copy. You can burn it, throw it away, rip it up, rearrange it, the pages, write on it, scribble on it. Although I'm not 100% sure you can actually scribble on it and cross things out. Like, the copyright law is actually not clear on that, because that is technically preparing a derivative work. I don't know. Gray area, ask a lawyer. And then transmit work publicly, which is like radio, or television. So, you can't just play anyone's song on the radio, although there are some legal regimes that have songs that have been produced. The radio station can play anything that's registered with these two organizations. I don't remember the names of them off the top of my head. So basically, the radio station records everything they've played. They give a certain amount of money to this organization that figures out where all the money goes, and then each author of the songs and the recordings gets a cut. But it's weird. I guess internet radio is even weirder, because people were starting to play things that they didn't own the copyright to, and Congress kind of like, what do we do? Do we just crack down on them all? Maybe we'll find a way to make everyone win. So as I said, derivative works are pretty much mostly what we're going to deal with software. So copyright terms have increased over the years, and that's kind of a problem. I won't get too deep into that unless someone's really interested in that. There's a theory that says Mickey Mouse copyrights will never expire. So it was first published in 1928, and since 1928, 1976 added, what's that? Added about 20 years there, and then they added another 20 years in 98. Probably another 20 years. They'll probably get another extension on that, so that it can't go out of copyright.
So I guess that's the Disneys of the world is pushing this type of legislation.
Yeah, they're I've seen the term used, the congressman from Disneyland. Like they got some Congress people in their pockets. So yeah, we've gone to basically 14 to 28 years, all the way to 95 years basically, because if you want the 95 years, it's probably better than the lifetime of the author plus 70, and you probably incorporated and sold off your copyright. So 95 is pretty much where we're at for most things right now. Let's see. So ironically, modern software probably deserves a shorter time to be copyrighted. Think of all the software that was written in the 80s that you don't have, there's no commercial value in almost any software from the 80s, right? Any of those games. It would really be good to have those games still in use, still contributing to our culture. And also extended derivative works, like think about Doom. I was listening to a podcast of John Carmack from the guy that did Doom and those games. And how old is that game? 94, I think? And it's still kind of a viable game because he open sourced it. All right, so what's the process to copyright something? So since 1989, all you have to do is make the thing. That's all you have to do. So from the moment the work is created, or the term is fixed in a tangible form, as soon as you write it down, it's actually copyrighted, at least in the United States. And anyone that is a part to the Berne Convention of 1976, which is basically all the countries said, okay, we're going to follow the same rules, so it's easier between countries. So before 1989, the copyright statement was required. So the copyright statement is the C in a circle, copyright, Craig Buchek, 2020, all rights reserved. You've probably seen that. People still put it in, front page of the book, probably still says that. And there's still good reasons to do that. It helps find out who is the copyright owner. And also, if someone knows who the copyright owner is, it helps them figure out, okay, if I need to ask permission to copy something, I know who to go to. And if you write that in there, it's a little hard for someone to say, I didn't know that it was copyrighted. Well, yeah, you did. If you want to file a lawsuit about copyright infringement, you do have to register it, which is weird. So, things get really weird here, or vague or contradictory from everything I read. It said that you have to register it within 5 years of publication. I'm like, well, what if I want to file my lawsuit 6 years in? How does that work? It's not clear at all to me. I guess we should find a lawyer and ask him. Let's see. So registration is optional, but recommended, I guess. Yeah. You register with the trademark office, the copyright office, which is a part of, I don't know if it's patent and trademark office or I think it's Library of Congress. Yeah, I believe you can do it online. There's another reason you want to register your copyright. It provides, I'm going to say this wrong, prima facie evidence of the validity of the copyright. So prima facie means Latin for at first sight, which means accepted as correct until proven otherwise. So basically, if you have registered the copyright, someone violates it, and they're like, no, I wrote that first. Well, without some really good proof, you've got the case won already. This is something I learned this week, mandatory deposit, which is odd to me that I never knew about this one. So you're required to send 2 copies to the Library of Congress. You're required to send 2. This is news to me. And I have done many copyrighted things because I have written things down. And I've never sent one, much less 2 copies to the Library of Congress. So, and this has to be done within, it's supposed to be done within 3 months of publication. And there's some exceptions for online only electronic works, which is what most of my stuff is now. So, okay, I'm exempt. So there's also, all right, if you don't send it to them, they can request that you send it to them, and they can fine you for not sending it to them. I'm like, what? This is crazy. And as far as history goes, this has been a thing since that Treaty of Anne, when was that? I don't remember what the date was on that one. So actually, this whole repository concept has been around for a long time. In England, you had to send it to either the King's Library or one of the universities. And I think at the beginning, it was just Cambridge and Oxford. I'm like, whoa.
Is the registration process cumbersome?
No. The registration process is not very cumbersome at all. It's pretty simple.
It seems like the mandatory deposit might more of a pain.
Yeah, it seems like it. Yeah, I mean, you got to mail it, but hopefully, if you're publishing an actual book, hopefully they'll take care of all that for you. 2 copies isn't a big deal. Mail it to them. Yeah.
The fixed change filter.
Yeah.
Does that, like the fixed part, does that mean once it's done being worked on, like if I'm writing software, is it copyrighted as soon as I start writing it, or do I have to like release it?
Yeah, there are some differences between when you create it and publish it. Things get a little fuzzy there. And things aren't very clear. So let's say you wrote some software. Let's say I wrote this presentation in 2003, and then I updated it in 2020. I believe that means that portions are copyright 2003, and other portions are copyright 2020. So let's say we come to 2115, 2105, whenever the 95 years comes up, right? I guess 95 years from 03. So 2098 comes around and someone's like, hey, that's a great presentation. Like, okay, it's 95 years old, but hey, I'm stealing it. They're free to take the part from 2003, but not the part from 2020. And things get really complicated and muddled there, but yeah, I think you probably want to pick the beginning or the end, or I don't know. Things get weird in the memo. Let's see. All right, fair use. So fair use. All right, so you've got these rights that you're the only one that's allowed to make copies of the book or what it is. But people can make copies of small portions for various reasons, and that's called fair use. So it's permitted use in certain circumstances, and there's 4 factors to determine whether something is fair use. And these come, and I actually read these in Section 107 of the Copyright Act today. So these are not quite verbatim, but pretty darn close from the actual law. So the 4 factors when considering, again, you got to get lawyers and judges involved if you get sued over this thing. But there's a lot of precedents, and so generally, one that's pretty familiar with, I'm pretty familiar with where these lines are drawn. But if you get really close to the line, you probably want to talk to a lawyer. So the purpose and character of the use. So if I'm using it for profit, I'm taking a part of your book and I put it in my book, and that's commercial use, and that's worse than if I had just done it to hand out to my class. Or it's more fair use to use it in class or nonprofit than for commercial gain. The nature of the copyrighted work. So, I don't quite understand the exact boundaries of that one. The amount and the portion of it. So, if I took your whole book, that's clearly out of line. But if I took a paragraph, that's probably fine. If If I took a few words, definitely fine. The effect of the use upon the potential market or the value of the copyrighted work. So if I did something that, made your book less valuable because I gave away, maybe I gave away the ending, or I just published the first page and last page of the book. Cliff Notes might actually be in trouble here, come to think of it.
There's a lot of summary books in Amazon I see all the time. It's like, wow, how are they getting away with this?
So I guess they don't use any verbatim words, or very many verbatim words. Like if they did a paragraph here and a paragraph there, and that was the entire book, was just paragraphs stolen verbatim, they'd probably be in real big trouble. But they're just expressing the ideas from the book, and ideas aren't copyrightable.
That fourth bullet point, a lot of the stuff is based.
Yeah, that's a good point. That does affect the market. So I guess they get around it by not using hardly any verbatim portions. Like they'll use names, obviously. Let's say Romeo and Juliet, but that's not copyright anymore because it's too old. But let's say one of the things it said was names aren't copyrightable. So, and it's also such a short thing that it's not copyrightable. But
You see a lot
yeah.
in the business book market. Blue Ocean Strategy is about 400 pages, but then there's a summary of it.
Yeah, those are probably more borderline because they're probably stealing parts more than just ideas. Yeah, those two pretty, well, really all four of them, you gotta take them all in total and figure it out, and it's a lot of.
Specifically pays royalties to newer books, and everything else is through fair use because it's old. It's kind of under the same terms as a review would be.
Yeah, like review, and it's weird. I should have covered reviews because critical reviews actually have a nice carve out that's pretty well defined. Like, yeah, critical review. This is for critical review, whether that's a movie review or a literary critique, which is a little more in depth. Like those are generally like completely allowed. All right. Anyone know why I put that as the background for this? That is a pattern that is trademarked by Burberry. So trademarks applies generally to names of companies and products, but it could also apply to phrases, I believe catchphrases, slogans definitely. I forgot to put that one up there. Logos, sounds, NBC, like that's a trademark of NBC. Maybe it's fair use. I'll get to a slide later. Colors, Pantone colors. Pantone has these 1,000+ colors, and they each have a number, and they're very specific. Those are actually trademarked. All those colors are trademarked. So if you want to use a Pantone color that exactly matches that Pantone color, you have to get permission from them. Now, you can be pretty close and not be the exact color, and that's, as long as you're not using the same name and the exact same color, you're probably good. Smells. Well, that's news to me. Like, how do you, perfumes. This actually matters in the perfume industry. This is a trademark scent. Like, you can't do a knockoff scent that's exactly like this. Now, how do you know what's exactly like another scent? I have no idea. And I'm a super smeller. Like, I have a very sensitive sense of smell. So trademarks cannot be just a description of the item. This is probably why liquid plumber is spelled wrong. Although liquid plumber is not quite a description, but it's sort of a generic term. Trademarks do not, as opposed to patents and copyrights, have no expiration as long as they're still in use, which is kind of cool. Interesting, there was no such thing as trademarks before 1870. The other funny thing was the Trademark Act of 1870 was struck down by the Supreme Court because Congress tried to use an extension of the copyright clause of the Constitution, and the Supreme Court said, it's not going to fly. So 1881, they tried again, and this time they based it on the Commerce Clause, the Interstate Commerce Clause, and now we have trademark law. All right, so what's the purpose of trademark? To reduce confusion in the market. So if you had Coca-Cola, if you had Budweiser, and you had Budweiser from another country and they tried to sell it as Budweiser here, which actually has happened, there's confusion in the market. Like, well, which Budweiser is this? You know, what's it going to taste like? What's the quality? Like, is this knockoff any good? You know, knockoff Levi's. Like, you can't just make a knockoff Levi, put your own Levi on it, pretend like it's Levi. That confuses the consumer. It damages the consumer because they're paying probably almost the same amount, getting lower quality. So the purpose of trademark is to prevent confusion between competition, protect the consumers from those kinds of fraud, and distinguishing things from one business from another business. So what rights do you have if you have a trademark? You have exclusive use of that mark, those words, phrases, colors, smells. Now it's restricted to the products or services that it's registered for. So if I have a laundry detergent called Linux, and I have an operating system called Linux, not much confusion that those, oh, did Linus Torvalds make some laundry detergent? No, you're probably not going to think that. So no confusion, it's okay to have two different things. Another case is McDonald's. You go to McDonald's, the Golden Arches. I don't know if it's still there, but back when I was, younger, I went to McDonald's Pub and Grill. They served burgers, but they weren't confusable with the Golden Arches McDonald's, so it was okay. So there are some exceptions, though. Like if you tried to, let's see, what was the example? Let's say there's a company called Sony that makes electronics and they make movies and sell CDs, and I made some sunglasses and tried to pass them off as Sony sunglasses. It probably can confuse people. You're going to think, well, is this that Sony or is this some other company? So because Sony is, I believe, a made-up word, that actually helps it have a case that, it's going to cover a wider variety of things than McDonald, which is a common person's name. I actually made a mistake once. I was traveling through Nashville, Tennessee, and I stopped at this hotel. I'm like, oh, this looks nice. It's Hallmark Hotel, and it had the rose. Well, wait, I didn't realize it then, but Hallmark Cards has the crown, and American Greetings has the rose, and I'm like, oh, this must be a Hallmark-owned hotel. No, it was a dump, and I was like, I did not stay the next night. So that was a sneaky use of trademark terms to confuse me. That probably shouldn't be allowed in that case. Let's see. Might be limited in territory. So sometimes, and this gets a little more iffy. Let's say it's the 1920s and someone came up with the Dairy Queen and someone else in another state, 20 states away, came up with Dairy Queen. There's no overlap at that time because it's too far away to know about each other. That would have been okay actually back then. Now it gets a little more iffy. There was a case where that actually happened in the 50s in Australia with Tasty Freeze. Two different companies decided to take the name Tasty Freeze, unrelated to the U.S. Tasty Freeze. And actually the first one that registered that trademark ended up winning it, even though it wasn't related to the American one. So you can license others to use the mark, although you have to be careful with that, because if you start licensing it to too many people and they're generating crap and it gets confusing, you can have a problem with that. So there is fair use in trademark, like there was in copyright. So if you're making a commercial and you're making, and you want to talk about how you're better than the Whirlpool, you can use the word Whirlpool in your ad. It's okay because you're not confusing anything. You're saying that thing that's called Whirlpool, I'm going to call it Whirlpool. It's okay. You don't have to call it Brand X. Now, whether it makes sense to use the term Brand X versus Whirlpool, that's your call, but it's not illegal to use the term Whirlpool in that commercial.
So when you see those sort of references, especially in trademark, that say Whirlpool is a registered trademark, is that required by the trademark?
I'm not sure. It'll keep you out of more trouble. It isn't necessary. It's probably helpful. Like, I guess the question is there confusion that you're representing Whirlpool or not in that case? So I've also seen, well, first of all, if it's a print ad and you do Whirlpool with the TM or the registered trademark, that's probably sufficient actually. Some places I've seen actually just say, just make sure it's capitalized, or oddly with Unix, it's like, it should always be all caps. I'm like, that's not how English works, but okay. Yeah, there's varying advice on that. So if you want to be, as lots of lawyers like to be, the most conservative, yeah, go ahead and put, this is a trademark of whoever it's a trademark of. So not only did you have fair use, but you've also got the, hey, not only was this fair use, but I made sure that no one was confused by this. Let's see. Let's see. Oh, using someone's trademark in your domain name, this is something that applies to us, might be an issue. But it matters. Are you trying to exert free speech? So if you register FullStackers.com, that's actually, there's sure been a case on that specific one that says that's okay, it's free speech. No one thinks that Ford registered that site and that's Ford's site. Now, when you do Bernie Sanders 2020 and you're the Republican Party, you might have a problem because you are trying to create confusion there.
Is there a case of, I want to say it was Madonna, maybe somebody ended up losing it to her?
I'm not familiar with that one. That could go either way though, because Madonna's sort of a generic term, like the Madonna is. Like if it was the Madonna, like she would have a hard time getting that one. If it's just Madonna.com, she probably had a good case. I would guess it probably got settled out of court and she probably gave $10,000 to go away or something. So what's the process to create a trademark? So there's sort of two different kinds of trademarks. Use the mark in the marketplace, put a TM on it, you're done. It's sort of a common law thing. Now, if you weren't the first person to use that, you're probably going to have a problem because that's creating confusion. So you can also register it with the U.S. Patent and Trade Office. Then you get to use the R in a circle, register trademark. So they will review it. You have to pick what category you're in. Like I said, and there's a lot of different categories with the Linux example, like laundry detergents. It's probably not laundry detergents. It's probably home products or something like that. And then there's computer software. Those would be two very different categories. So you send it in. They review it, make sure that it makes sense. It's in the right category. It's actually legitimately being used, or it doesn't come too close to something else. And then it's published for, I think it was 60 days or something, pretty short actually. For opposition, Linus can come say, oh, actually, I think that laundry detergent might create some confusion. I'm going to contest this, and I don't want you to give that registered trademark. Actually, I think that actually happened not with laundry detergent, but someone that wasn't Linus registered Linux, and with the help of the Linux Foundation, they fought it, and they now own that trademark instead.
So what's the relationship between, like, when you register a trademark for a thing and when the development state of that thing? Like I can imagine you're working on some product, but you wanted to, decided the name is a trademark.
Yeah, I think that's the case where you'd want to register it because you're not using it yet. So I think that's one case where you'd want to register it to make sure that you've sort of reserved it.
So you can register for a thing that basically
That doesn't exist. And I've got it on a different slide. What I've read, if you don't use it, it'll go away in like 3 to 5 years. But so that gives you a 3 to 5 year window to actually finish that product, make sure you got the name. Because yeah, it would be tough to Apple comes out with something called iTunes, and they've been working on it for a year. They put the branding on, that past 6 months, and then, the day before they release it, someone registers the iTunes trademark, and they're like, oh no. So yeah, that's probably the reason that registration exists beyond the just using it and asserting your rights on, hey, I was the first one to use this. I think that's why that distinction, those two different distinctions exist. Trademark erosion. So I just said, if you don't use it, you lose it. From what I've read, it's 3 to 5 years, typically. And if you don't defend it from dilution, you can lose it. So I've got a lot of examples here in the notes. So my favorite example is probably Kleenex. You know, I write on my shopping list Kleenex, but I never buy Kleenex brand, I buy Puffs. Like, so to me, Kleenex is generic. And if Kleenex, the company, doesn't fight that, I guess it's whoever owns the company or the brand, if they don't fight that, they could actually lose that and it could become a generic term. So if you notice, if you look at Kleenex or Puffs, it says Kleenex brand tissues, Puffs brand tissues. So they try to be specific that there's the trademark name and then there's the description of what it is. Those need to be quite different, actually. That's one. So I'll list off a few that have been lost and become generic terms. Aspirin, dry ice, laundromat, cellophane, trampoline, dumpster, and zipper. Almost all of those are news to me, actually. Dumpster was a company called Dempster. Their last name was Dempster, and they were a trash service, so dump and Dempster became dumpster. It was pretty cool, but they lost it somehow. I don't know exactly the details there. A couple that are probably in jeopardy now, Xerox, although probably less than in the 70s and 80s where you're like, hey, make me a Xerox. It's probably safe. Kleenex, jacuzzi, no one ever thinks of that as a, you know, I think that's just generic. It's a tub with jets in it. Crock pot, this one's news to me. Ping pong, it's a trademark of Hasbro. What? So any ping pong tournament is not a ping pong tournament, it's a table tennis tournament. Thermos and Velcro. I actually had Velcro on here. Yeah, it was on the list. I think if you Google something, usually you use Google, but yeah.
So concentrated market, people do actually use
Yeah. That's a little more gray than some of the others for sure. All right, patent. Someone patented the toilet paper roll apparently in 1891. Or maybe, I don't know if it was the first patent, the toilet paper roll, or some, just as a short tangent. Toilet paper's still being improved. Like, you know, in my lifetime, we've gone from regular rolls to jumbo rolls, and like, someone is still thinking about these things? This is crazy. Anyway. So patent covers innovations, inventions, methods, and processes. Again, it's part of that constitutional clause. To get a patent, it has to be novel, so it has to be a new idea. It has to be somehow different than any existing ideas. It has to be useful, which means if you try to patent a what do you call it? A machine that gets infinite energy. Motion machine. Not patentable because it's not possible. It's not useful because it doesn't actually exist. And it has to be non-obvious. I can't come up with a good example of this one, but like I suspect that the jumbo roll of toilet paper maybe is obvious. Hey, you had 200 sheets on that roll? I put 300 sheets. Probably not patentable. Now the thing that extends your toilet paper holder, patentable. So the Mach 5 razor came out, and it had 38 patents. I'm like, there's not 38 pieces here. I don't understand how you can have 38 patents. Lawyers sometimes get involved to make things complicated. Software patents are an awful, awful thing. I would urge you to fight against them if you can. So luckily we've gotten a little bit that's pulled back in the past 20 years or so on how strong patents are, but there are patent trolls out there that they collect patents and sue people Actually, there's also copyright trolls that, like, if you download things and they catch you, they sue you for $10,000. And you're like, it was a minor infringement. It's not really worth $10,000. But there's the same kind of things with patent trolls. Someone patented, and this should have been an obvious thing. They patent something that existed and then kind of put the words on a computer or on a network. And so, oh, hey, you're displaying pictures on the internet. So I'm sorry, I'm going to have to sue you. I'm like, what? And so a lot of companies will pay because it costs a lot of money. You know, for a big company, it's going to cost a couple $1 million to fight a lawsuit. So $100,000 to get them to shut up, it's actually an effective business plan, sadly. Where it really sucks is where, you know, mom and pop shop has to pay that $100,000. They don't have that $100,000. They don't have $10,000, and they might try to sell, you know, get you to settle for $10,000, but that's a terrible, terrible thing. I've seen less of that in the past 10 years than before that, though. Okay, so what's the purpose of a patent? So as the Constitution says, it's to promote the progress of science and the useful arts. It's to give a financial incentive for research and development. So it's a trade-off. So in exchange for disclosing how you're making your new thing, we're going to give you a limited time monopoly on making that thing and distributing that thing. And that's typically 20 years. During that 20 years, you have the ability to exclude anyone else from making, using, selling, or importing that invention. And you can, like the other ones, you can license it to others. Note the using there. I have a bit of a difficulty with that one, and I'm not sure where the boundaries are of that. Like, if I independently discovered something and started using it, and you patented it, possibly even after I started doing that, but I've never published the fact of how I did it, then I can actually be sued for violating their patent. And I find that a big problem. Some countries do allow exceptions for that. In the United States, as far as I know, does not have an exception for. I've been doing it since before they published that patent or submitted that patent.
Did that change about like 15 years ago or so? It used to be first to invent, and they changed it to first to file. So it used to be that you could prove that you had invented something before somebody filed, that you can get an exception. But now that it's first to file, it's literally whoever gets looking on first.
It's always been first to file because Alexander Graham Bell beat the competitor by like a day. And he's now the father of the telephone and not that other guy that I don't know his name. So I'm pretty sure it's always been first to file. In fact, it's in my notes on this page here, as far as I know. So there is an exception to that, and that's prior art, which I believe I have a definition here. All right, so let me go through the slide, and I'll cover that hopefully correctly. I don't know. So to patent something, you have to write up a description of how to make and use the invention, whether that's the process or how to make the thing, whatever that is. You have to provide sufficient detail for someone to replicate that process or making that thing by someone skilled in the art. And that means that someone that's actually a professional in the field of the thing that you're dealing with. So if you're making a software patent, hopefully you probably have to, or you should be, writing it up in a way that a computer programmer can or a computer scientist at least can understand and make it work. Because that's the whole deal, right? The deal is that you show the world how to make this, and we'll give you that monopoly on it for 20 years. If you didn't really show it and you still have a monopoly, you're cheating the system, and we don't want to allow that. If you've never looked at a patent, I urge you to look at a more modern patent than the toilet paper one, although it is kind of fun to look at the old and the arrows and the numbers and all the things. But they usually have a claim, and it's usually, they're all very similar. So let's say I'm doing showing a picture on a network. So I might say, number one is showing a picture on the internet And claim number 2 might be showing a picture on the internet with color. And it's like, okay, that seemed to be, and then, you've got all these combinations of different things, of ways that you can do it, so that you make sure that you've covered a wide enough space of all the different ways you've thought of. One time I thought of a speed sensitive or I'm driving my car and I'm on cruise control, and I start going up a hill and it wants to downshift. I'm like, well, wouldn't it be nice if I could patent that says, hey, if I'm going up a hill, I can slow down a little. I don't need to downshift and rev the engine higher. I can go a little slower when I'm going downhill. When I'm uphill, I can go a little faster when I'm going downhill. I'd like to vary that. It's already a patent. It's already covered by someone's. There are so many patents for that already that I'm like, it was mind blowing. Okay, so you've got these claims that cover the scope of the patent. Okay, it covers this direction and all these things. And then, so it gets reviewed by a patent examiner. Who's the most famous patent examiner? Albert Einstein. So, I mean, that's what he did. So he assessed it for prior art. Okay, do I know of anything that's like this? Is it obvious? Is it useful? Could I actually make this thing? Is it a perpetual motion device? So this will likely take a long time, and they will likely reject it, make you make changes. This could go on, probably will go on for several years, actually. Prior art. So prior art is public information that's relevant to the patent's claim of originality. And that can be in any form, and it must exist before the patent application date. Although I have seen some cases where they file a patent and then they amend it or they change it, and they added some things that were prior art in that time period and it wasn't allowed because I think the patent examiner looked at the original patent application date instead of when they had amended that patent. That's not supposed to work that way, but I've seen it work that way. First to file, as far as I know, it's always been the way in the United States. Maybe it was, maybe some other countries have changed it that way. I think it was maybe Europe in the past few years that changed it, maybe. But unless there's prior art. So had the other guy published how to make a telephone before Graham Bell had gotten to the patent office, neither one of them would have gotten a patent because there was prior art. Although it's a little more murky whether the guy had first published it, could still patent it. I think I've seen both directions on that one. So I just learned, or relearned probably, that there are yearly renewal fees on a patent, so it does cost you to keep it going. I don't know. I didn't look into that. They do vary? More expensive. That's interesting. You'll probably want to get help with this process because patents are written in sort of this weird, it's sort of legalese, but it's not quite the same. They're really hard to read, which is kind of antithetical to the whole purpose of them, I find. It's weird, it's a pain. I've never bothered to go through the process. I've considered it a few times. You can do it yourself. I don't know how much sense that makes. If you do want to do a patent on your own, go read the No Low Press books. They've got really good legal books. Also, if you want to, if you want to start your own company and create an LLC, they've got a book for that. Although at this point, probably just pay someone $60 or just go to Missouri and register. And it doesn't take that much. It's not quite a book's worth of information anymore. What I read said it'll probably cost you $10,000 to $30,000 to file a patent. I assume that's with lawyers. All right, licensing. This is probably the more important part for us. All right, so if you don't have a license for a copyrighted work, what happens? Copyright law applies. So you can use it if you have a copy. All right, that's pretty straightforward. As long as you've purchased it or you got a copy legally. You know, if you have a stolen copy, yeah, you probably can't use that copy under copyright law. You'd be accused of copyright violation or theft, one of the two. Not a place you want to be. You cannot give a copy to anyone except your original copy. It's called first sale doctrine. It says that, you know, I got this book. I don't have to ask the author to go sell that book anytime, you know. Secondhand bookstores wouldn't exist without first sale doctrine. You can't make copies. It's the point of copyright. You don't have the right to make a copy. So, except for backup purposes, archival purposes. So this was more important back in like the 80s when you got a floppy disk with, you know, whatever game with it you had, and you wanted to make sure that, you know, bit rot was a thing that happened a lot back then. Or you put it next to the monitor and the magnetic field erased it. So you are allowed to have backup copies for your own use. I forgot to write it down here. If in the use of the product, incidental copies are made, that's okay too. So in other words, I've got this software that's on this floppy disk that gets copied into memory on my computer. That's incidental. It doesn't count as a copy as far as copyright goes. You can't copy substantial portions. We talked about fair use, that kind of how much you can copy. And you can't make modifications. Now this one's not 100% clear to me. Can you make those modifications? Can you cross a word out and, you know, change it? And then sell it? Like, no one's going to give you trouble if you know, just do it on your private copy. If you try to sell copies, in fact, there are court cases about this. So there was a company that took rated R movies and made them basically rated PG, or G possibly. And they got sued by the companies that made the R movies, said, we don't want you doing this. The movie companies won that case, actually. I don't know if it was settled out of the court, though, and so that kind of doesn't set a precedent, really. So things get a little vague there when you're modifying, especially your own copy. But then are you doing after that with the copy too? All right, so a lot of the licenses we use these days are free software. So what is free software? So free software, there's actually 4 freedoms. And because we're programmers, we're idiots, I'm not sure which, we started numbering them at 0. So the first, I think actually there was freedoms 1 through 3, and I think they added 0 after them, to be fair on this one. So the freedom to run the program for any purpose. Copy law actually already gives you this one, but okay. Actually, like get a Microsoft license, the license for Windows or the license for Mac OS. They make you give away your rights that you already had in order to run the program, which seems a little fishy, because you would have had those rights had you not agreed to that. So freedom 1 is the freedom to study how the program works and adapt it to your needs. And you have to have access to the source code to make that a viable thing, to make changes how it works. To make it normally easy. I mean, there are people that will go and edit my code, but those people are freaks. Any freaks in the audience? All right, just checking. The freedom to redistribute copies so you can help your neighbor. That's a weird way to say it, to help your neighbor. Okay, this guy's, all right, maybe this guy's okay. And then you learn a little more about the guy that wrote it, and maybe he's not okay. The freedom to improve the program, to release your improvements and modified versions in general to the public so that the whole community benefits. Well, that's pretty cool. So again, you have to have source code to make that happen. So that's basically, if you're talking about free software, a free software license, it has to meet those 4 criteria. And that comes from the GNU project, the Free Software Foundation. And it's free software. All right, so Richard Stallman is the one that started this free software movement in 82, 83, 84, somewhere around there. Which, by the way, if he tells you the story, he says, oh, it's always been about freedom, like free as in free speech, not free as in price. But if you actually go look at his origin story as far as free software, he talked about the fact that the manufacturer wanted to charge $200,000 for the printer driver license. He's telling a little fib there. Anyway, so 1998, some people got together and they said, you know, free software is really great. It helps us write really good software. Got these really good things, but people stop on the word free. They think free means no cost, no value. And they knew that this was not the case. They knew it had great value, actually. And so they're like, well, let's see what we can do about renaming it. Because we're not really concerned about freedom. We're concerned about this makes good software. And so they came up with the term open source. I was actually around at that time and wish I had contributed. And I think I would have liked to call it free source software because the free source is the one that has to be free in price and in freedom. And that's kind of the important part. And just because the source is free doesn't mean that the product is free. So I would have liked to have seen that sort of compromise, but that's long gone now. So they focus on free distribution and the integrity of the source code. The open source definition is basically, it's very similar to the free software definition, but we actually added a couple things. You can't discriminate persons or groups. You can't say this can be used by anyone but the military. That does not meet the open source definition. You can't say that this can only be used by scientists. You can't say that this license is only for Mozilla. If Mozilla writes a license, which they have, it has to be able to be applied to other products. Let's see, technology neutral. And so actually you can go to opensource.org and they've got a list they've got this definition and they've also got a list of software licenses that meet that definition. The Free Software Foundation has ones that meet the free software definition. All right, so as I said, free software emphasizes freedom and open source emphasizes that it's low cost, it's flexible, you have control. Companies love control. They don't care about freedom, but they love having control. And I actually got to talk to Solomon, and I'm like, aren't those kind of two sides of the same coin? He kind of admitted that. I'm like, yeah. I tend to use these terms interchangeably. So software libre, or libre software, FOSS, which is free open source software, or free libre open source software. Anyone have questions about those? All right. So there's an OSI list. Open source initiative is what opensource.org is. So most programs are just going to use one of these. They're going to use the GPL, maybe the LGPL, but it's kind of, even the guys that wrote the license, you probably shouldn't be using it. The ones that you're probably likely to run into these days are the BSD, the MIT, and the Apache licenses. And I'll cover the difference between them in a bit here. So the GPL, the GNU General Purpose License. So it's not the GPL license. It's like saying ATM machine or PIN number. It's just the GPL. So you should read it. You really should read it. It's not that legalese. A friend of mine has given courses on open source, and he has the students read the Microsoft end user license agreement from Windows. It's probably like 20 pages. And the GPL is probably about 4 pages, which is actually pretty long for a free software or open source license. But it's written in really readable English. It's not very legalese, really easy to understand. And it's interesting watching the students. He has them read it in class, and he's like, what's the difference? He's like, I can read this one. And the other thing is, the end user license takes away rights, and the GPL actually gives you additional rights that you didn't have under copyright law. All right, the BSD license. So BSD stands for Berkeley Software Distribution, Berkeley, UC Berkeley, University of California in the Bay Area. So it comes from their variant of Unix called BSD Unix. There's several variants. So the original was called the 4 clause. And the 4th clause is no longer in them, is that you had to recognize the UC Berkeley regions as the owners of the code. And like, well, that doesn't apply to software I'm using under BSD, releasing under the BSD license. So like, it didn't fit the open source definition because it was specific to that author, basically. So the newer standard then was the BSD, the 3 clause BSD license gets rid of that. So these 3 clauses, again, this is actually very short, and actually, yeah, it's too hard to pull it up on that screen. It's about 4 paragraphs. 3 clause version about very long paragraphs. So there's even a shorter version. There's 2 clauses, which removes the thing that says the authors of the software, or it says something like the I don't remember if it's UC Berkeley doesn't endorse this software, or if it says the authors don't, endorse anything about this. Really simple license. The other licenses that you might come across, the MIT license is basically the same as the BSD license. Basically, they sort of independently came up with the same license, just slightly different text. I know that's the one that I encounter the most because Ruby is under the MIT license, and so almost all the libraries are MIT licensed. The LGPL is basically the GPL, but it has an exception on linking non-GPL code. So the thing about the GPL is, if you use GPL code in your code, the only way you're allowed to do that is to make the whole thing GPL'd. Now you're like, oh man, that's a terrible license. No, that's actually copyright that's requiring that. They just don't give you an exception for combining your work and my work. Like if you took Microsoft's code, they're not going to let you combine your code and their code either. Apache license. It's similar to the BSD license, but significantly longer. Like it's probably about 2 pages, maybe 3 pages long. And it has clauses pertaining to patents and trademarks. It grants you the right to use any patents that the authors own, but does not grant you the right to use any trademarks. So if you use Debian GNU Linux, you can find a version of Firefox, but it is not called Firefox because the Apache license that they use, actually I think it's the Mozilla license, but very similar clause. They grant you the right to use the software, but not to use the name because the name is trademarked.
So that's the same thing with like Chromium or
Yeah, well, Chromium is another example where you can use the term Chromium, but you can't use the word Chrome. And that's a slightly different distinction because Google actually releases Chromium. The Debian GNU Linux version of Firefox is called Iceweasel. So, it's a similar logo, but not the same. So, kind of fun. So there's a little more lenient license called the artistic license. This was very popular in the Perl days, late 90s. I haven't seen it for a long time. I probably should take that off of the talk. And Sun and IBM have some open source licenses that you might come across.
I'm not a Java. I was kind of confused by Java, how it fits into this. Like even pre-Oracle,
So one of the Sun licenses, there's a couple Sun licenses and a couple IBM licenses. The IBM license that sticks in my mind is the Eclipse license. That's probably the one you're more likely to run into these days. Even in the Java world, like any Java library that's come through IBM, it's probably going to still use that EPL, the Eclipse public license. I'm afraid I don't remember the details of I haven't really been in the Java world since the late 90s or something. Yeah, I don't even remember how they differ exactly. I will tell you that the Sun and the IBM licenses are significantly longer because they've got lots of lawyers that pay lots of money, and so the it's weird when you look at contracts and licenses and how sometimes they try to like cover every situation, which in some ways though, the more you squeeze, the tighter things squeeze out. So yeah, what's that? Right. Okay, so public domain. So public domain isn't a license per se. It's when the thing isn't copyright, either because it's expired, it couldn't be copyrighted, it was made by the government, because the government can't really hold it, maybe. And it was something's public domain that it means the author has no rights to the work. Now that doesn't mean you can say mean things about the author necessarily, but as far as making copies and all the things that copyright restricts to one person, that's anybody can make copies and modifications and everything. So there's some controversy whether you can explicitly make something public domain, especially since '89 when you don't have to assign any. You don't have to register it. You don't have to copyright statement on it. So it's not 100% clear whether you can explicitly make something public domain. I'll talk about that in a bit. So the public domain as a collective thing is a commons of works that anyone can build on. So, and unfortunately, like I said, Mickey Mouse was 1928, and so no one's been able to take Mickey Mouse and riff on it, sort of. I mean, there's some gray market things where, really terrible things that Mickey Mouse is doing. But no one can really release public Mickey Mouse except for Disney. Now, okay, maybe that's not a terrible thing with Mickey Mouse, but think of all the fairy tales that Disney has taken over and sort of claimed as their own. So they've actually taken things that we could build on and kind of taken it away from people being able to build on. So that kind of takes away from our culture or the ability of us to mix different things together. And that's what creativity has always been about, is taking existing things and changing them and making them better. So public domain is actually a very important thing to have, and unfortunately we don't have much of it now. This isn't very important. So in the early 2000s, Microsoft said, oh man, this open source stuff is catching on. We need to do something, so we're going to have this thing that's called shared source. And it's kind of a halfway attempt to be open source, but still keep control. Microsoft, since their current CEO has really changed their ways. I mean, they bought GitHub. People were like, oh no, it's not Bill Gates' Microsoft. It's not Steve Ballmer's Microsoft by any means. They get it now. I mean, Ballmer had called the GPL a cancer, and he's like, oh, you get the GPL and infect all your software. Well, if I use Microsoft's code, I'll infect all my software. It's not the GPL. So actually, Microsoft is almost exclusively open source licenses for anything that they don't sell you as proprietary software. That was a bit of an abrupt jump. Let's see. Okay, so it's one thing to copy code and use it for yourself. But if you're just using a copy of the software that you already got, how can I use that? When can I use that? So actually, that's not right. This is actually using source code. So if you're using someone else's code in your own, you're creating a derived work, a derivative work. So that original copyright, you have to still honor. And you have to, hopefully there's a license that says you're allowed to make those derivative works. So whenever you are taking a library, you should check, what is its license? Is that license compatible with what I'm working on? And I'll give a summary of what's okay to use and what's not. But be careful with GPL code. pains me to say that because I was for a long time a big fan of the GPL. But just realize if you use GPL code, you need to make your whole thing GPL if you plan to distribute any copies. If you're just going to use it internally, you can make those modifications because you're not distributing. It's actually allowed. For BSD licenses, you don't need to make your code BSD to use it. You don't even have to make your changes available or your own code available. You can just use it. And same with MIT, or any of the BSD-like licenses. So I liken this to like slavery and freedom. So which world is more free? A world where you can be free to do anything, including owning slaves, or freedom to do anything except own slaves? Like which world provides more freedom? I think we've clearly decided on that one now, right? I find a similar issue between the GPL and the BSD type licenses. Like, this is the world I live in. That like working out pretty well for us. People find that it actually makes sense to contribute back even if they aren't required to. In some ways, I kind of like that world better because I'm not forced to contribute back, but I found that it's useful to even to me. And I could probably talk half an hour on why it's useful to me to release my code under open source. I'll give a couple of those reasons. So, all right, I write a little program and it's useful to me, and it doesn't cost me anything to put it on GitHub and make it open source. So that's one thing. And then now I get, oh, I had a bug and someone fixed my bug? Whoa, not only did it not cost me anything, I got something out of it. I can also put that on my resume. Hey, I've got a lot of open source software. People tend to look at your GitHub repos. And most of the software I work on is not open source. It's proprietary for a company. It's owned by a company. I can't share it. I can't show code that I've written. All I've got to show is my open source, and I've got a significant amount of it. Maybe not the greatest because I don't spend a whole lot of time once it's working for me. But it is something that people do look at when they're hiring developers. All right, combining licenses. Again, GPL. If you're using it, you got to be GPL. There are GPL compatible licenses. So if you've got GPL code and you want to add some BSD code to it, it's not a big deal. Just make sure it's GPL. It's probably dual. Some of the code is probably dual licensed. I believe there are several pieces of software that are, you can use this license or you can use that license. Sometimes that's a proprietary license or GPL or proprietary BSD. If somehow, using GPL or BSD doesn't work for your business, they'll offer you a commercial license. And some actually, is it the Linux kernel that actually says you can use this under the GPL version 2 or version 3. Various software does that. Those are roughly compatible. It gets a little hairy. BSD, you can actually, all right, so BSD basically has, the only rule is you have to not claim that you wrote it yourself and keep the copyright notice. That's about it. You can actually use your own code, but it has more restrictions. So, as long as you're following those two rules, you can add more rules. Some can be dual license. All right. All right. So there are actually open source-like licenses for other things besides software. The two most common ones are the free documentation license by GNU. It's not generally recommended anymore. The one I really like is the Creative Commons license. In fact, I released this presentation under that license. So if someone wants to give this talk next time, 17 years from now, whenever, you're completely welcome to. I believe I said that CC by. So you have to still say that I wrote it. Or at least the portions that I wrote, you have to say I wrote it. So their slogan is "Some rights reserved." play on the all, right? It's reserved. And it recognizes the importance of those shared cultural artifacts, that commons. But it's a voluntary commons of creative works. It can be used by others instead of, expired copyrights or whatever. And this lets us build on the works of others to build something even better than I could have built. And so it's got a series of licenses that you can apply to your works, and it takes the copyright laws into consideration, which actually all these copyright licenses take the copyright law into consideration. The GNU is called copyleft because it actually kind of uses copyright against itself. Like, okay, this is copyright, but I'm going to make sure that you can't prevent other people from using it, which is the whole copyright for preventing. So you basically get 4 different things to think about when you're picking a Creative Commons license. Do I want to require attribution? Do I want to say, hey, if you use this, you got to keep my name on it? That's one I usually pick to use. Do I want to say this is okay for commercial use or not okay for commercial use? I'm usually okay with commercial use. Do I want to allow modifications? And if I do allow modifications, do those modifications have to be shared or can they be kept to yourself? So a couple different sites allow for searching for Creative Commons licensed images. I usually use those when I'm looking for images for slides. All 4 of those images I used. I actually usually use it. So if you do a Google image search, there's a tools little menu on the right side. You click on that, it gets like 5 more drop downs, and you can say license type, and you can pick which of these. And they kind of map to these roughly. And then there's another Creative Commons license called the CC0 license, which is effectively releasing it into the public domain. Like I said, it's not clear if you can release something into the public domain, so it basically gives all the rights that would exist if it wasn't in the public domain by a license. So it's a little workaround by it for that thing. Okay, let's say you've infringed on someone's copyright. What happens? First of all, they probably won't catch you, so don't worry about it. But if they do catch you, don't do it. Okay, don't do it by any software you're writing for any commercial game. Definitely don't do that, because you're much more likely to get caught, and the damages are going to be much higher. So they can charge you for actual damages. If you intentionally violate and keep violating after they've told you, they can get you for punitive damages, which means it's just as punishment. If I'm suing you for punitive damages, I'm suing you for more than it cost me, what you did. And I don't know if there's, typically punitive damages are like 3 times as much as the actual damages. I don't know if that applies to copyright law or not. Statutory damages, which I think is $200,000. So that's if it was registered with the U.S. Copyright Office. So if you're publishing something with copyright and you want more damages if someone violates it, put that copyright notification on there. That'll help you with this one. Register it with the Copyright Office within 3 months, and it'll help you with this one. Now, it's weird because that says 3 months, but some other things said 5 years. I don't know. They can get an injunction from a judge to say, all right, you can't, that software that you made that you stole some of my software, you can't distribute that anymore. And if you've made profits from that software that you've stolen, you're going to have to pay for that too. So it's not worth it. So a little summary on licensing. Using free open source software, there's no restriction or requirements on just using the software. Commercial software that usually does. You have to follow the terms of the copyright law. With open source, that's pretty clear cut. But that's only if you distribute it and make modifications or might make modifications. Open source gives you additional rights. The GPL derivative works need to be GPL, but GPL or BSD licenses you're pretty much free. So here's a shorter stuff. Using open source software, no big deal. Don't worry about it. There's pretty much nothing you're going to get in trouble for. Distributing open source software, not going to get in trouble for doing any of that. Modifying and distributing open source software, as long as you include the source code, no big deal. If you mix open source with proprietary extensions, talk to a lawyer. Definitely talk to a lawyer. Unless that open source is BSD or BSD-like, like MIT. And then just make sure that you don't remove the copyright notices. Make sure that occasionally they might say something like you have to, if you ever play with like iOS or Android software and you hit the about and it's like, we use zip software, we use JPEG software. Like it's got a whole list of those attributes. And sometimes those are required to be not just in the source code, but in the end product. Sometimes that's just a thing that they're being nice and covering their butt to make sure. But yeah, just make sure you're covering your attributions properly on those. I urge you to actually, if you're interested in this, go look at the copyright laws. It's not hard to find. Copyright.gov is a good place to start. Read the licenses. It doesn't take very long to read the GPL. Definitely doesn't take long to read the BSD licenses. These are easily Googleable. The Copyright Office does have a FAQ, and you get quite a bit of material from them. And as I said, this is under Creative Commons. You can find the source code, and I have given this a few times. So thanks for listening. As we said, you can find me on Slack. Ask me questions there. Ask me questions now. Ask me when we disperse. I am free for questions. Anyone? All right. Thanks for listening.